How is mandatory car insurance constitutional? Mandatory car insurance is required by the states, not the federal government. Under the 10th Amendment, the states keep all powers that are 1. Not committed by the Constitution to the federal government and 2. Not prohibited to the states by the Constitution. Since nothing in the Constitution specifically gives the federal government power to require car insurance, or prohibits it to the states can require car insurance. One caveat is that Islam and some other religious beliefs hold purchasing insurance to be a sin, as a form of gambling. It thus could be argued that mandatory car insurance for those with religious objections to it infringes the First Amendment's free exercise clause. But under Employment Division v. Smith, this argument probably fails. The Religious Freedom Restoration Act protects Muslims against being forced to buy insurance by the federal government, but not against the states. Driving is not a right, it's a privilege. Therefore, to earn that privilege, the law in most U.S. states, as well as in most countries around the world, mandates that you either must buy insurance, put up a cash bond, or at least be financially responsible should you have an at-fault, full or partially responsible accident. Many people don't buy or are not financially responsible after an at-fault accident, and those people lose their privilege of driving until they pay off the other party for property damage and bodily injury. The 10th Amendment provides the states the right, and duty, to address legal and political issues not specifically within the authority of the federal government. There is no constitutional prohibition against holding one responsible for damages and injuries she causes. Driving is not a right. Driving is a privilege. Yes, since insurance is state-regulate. It falls under financial responsibility public good. The same logic was used when the Obamacare passed through the Supreme Court.